On November 28, 2018, rapper 2 Milli filed a copyright infringement suit against Epic Games, the makers of Fortnite. He claimed that they used a dance that he had created for his music video, The Milli Rock, in 2014 as an emote for the game without his permission or providing compensation. Multiple other celebrities whose dances have been used in the game would later follow his lead in suing the game developer. It was undeniable that Epic had recreated these dances and then sold them as in-game emotes, so the real question was whether or not a dance could be copyrighted. Appropriating the celebrities' identities to sell these emotes was also an idea brought to light. Following 2 Milli, Alfonso Ribeiro filed suit for the use of the dance he coined for his role on The Fresh Prince of Bel-Air, known as the Carlton. Third was Russell Horning, aka Floss Kid, for his Floss dance. As he is currently 17, his mother is suing on his behalf. All three are represented by the same law firm, Pierce Bainbridge, Beck, Price, and Hecht LLP, and are suing on roughly the same grounds. The complaints allege copyright infringement and violations of the right of publicity. The two claims are separate suits, but either one could result in hefty damages on Epic's part and significant shift in the games industry as a whole on creating emotes from pop culture. Next was rapper Blockboy JB, who filed suit on January 23, 2019 for Epic's use of his dance Shoot, known in the game as Hype. Being represented by the same firm as the previous two plaintiffs, he also added trademark infringement to the list of claims. The most recent claim came on February 25th when two former University of Maryland basketball players, Jalen Brantley and Jared Nickens, who claimed to have created the Running Man Challenge in 2016. Epic has an emote quite fittingly called Running Man in their game that is very similar to the dance involved in the challenge. Ownership might be an issue here because Brantley and Nickens have others claiming that the Running Man Challenge was actually launched by a pair of high schoolers named Kevin Vincent and Jerry Hall. Either way, the claim against Epic stands. While these are all of the current suits, there are many more emotes in Fortnite that have been taken from pop culture, presumably without permission. If one of these cases is ruled in favor of the prosecution, it's very likely all of them would be, and many other figures whose dances have been taken could step up to receive compensation. The question now is whether or not one can copyright a dance. If Epic used the songs associated with these dances, that would be clear copyright infringement, and if they made character models resembling the people who created the dances, it would be a clear violation on their right of publicity. This question is part of why we picked this headline to begin with. It is a bit odd to see a video game as popular as Fortnite put under the scope of law, especially for something like this. It honestly is quite entertaining to see such a large name put in the hot seat because of something a majority believed couldn't be copyrighted in the first place. I didn't have the vocabulary at the time, but it didn't seem like a tangible writing to me. Choreography is protected under copyright law, but individual moves are generally not considered to meet the requirements. Individual dance moves, like the worm, the Macarena, or the moonwalk, have historically been left out. The Copyright Office's own guidance is clear. Individual movements or dance steps by themselves are not copyrightable, but this is the first time that this has been argued in court. There is no case law precedent to follow here. On February 13, 2019, after a request to dismiss the case of the Carlton as too basic to be considered choreography, the U.S. Copyright Office agreed, stating that his dance is a simple routine made up of 3 dance steps, and therefore ineligible to be copyrighted. In one variation that was not rejected for copyright was a performance he gave on ABC's Dancing with the Stars, which was a longer dance, but the Copyright Office said that it is questionable if Ribeiro actually owns the dance, as it could be potentially ABC's or his dancing partner's, Whitney Carson. Interestingly, at this point in the case, the U.S. Copyright Office began receiving what appeared to be fake emails from one of the attorneys involved with the prosecution. In quotes, "Recently, I noticed that my clients and I have been filing copyright claims regarding dance moves. Please have them rejected right now. If any judges are working on them, I want your workers to tell them that they should be rejected or dismissed because they were containing very false information. What my clients and I have done towards certain gaming companies were very reckless and baseless. Once again, I would like for our copyright claims to be terminated or dismissed because they were false and baseless." Pierce Bainbridge LLP was seemingly behind these false emails that were sent to the Copyright Office, and they were sent under the name David Hecht, the lead attorney for the prosecuting team. Pierce Bainbridge LLP labeled these claims as false, and said the email must have been sent from a hacker. The law firm even went as far as calling the hacker a part of the uninformed minority, while teasing at the grammatical errors contained in the fake emails. With all this being said, it will be interesting to see what comes of this whole situation. As previously mentioned, a negative outcome for Epic Games could potentially change the game entirely, and with the popularity of the game already slipping away to competitors, it could be the final blow to what was at one point the most popular game on the market.